All right. Welcome to the Creative Finance Collective. We're here to talk about all things creative finance related. If you're watching and if you've come to ask questions, that's the purpose of why we're here. We're taking questions about creative finance. So make sure to post those in the chat, whether you're watching from Facebook, whether you're watching from X, or whether you're watching from YouTube. We're here to take those questions. So make sure to post those, like I said, in the chat. We'll get to those. Today we have with us, I'm Andy Fowler, and we have Sean St. Clair with us and Alan Seshker with us. Alan, how you been?
Real good, real good. Still busy with the investor stuff.
Okay, good. Well, you mentioned earlier you had a question to open this thing up with. What do you got?
All right, so I'm going to ask y'all a question. I'm going to ask it the way that it's usually asked in venues or otherwise, online venues. Um, how do you know if your title company is investor friendly?
Mm. Okay, that's the question. How do you know?
Yeah, I amend the question when it's asked that way, and I change a couple things in there. But I don't want to taint my witness. I want y'all to answer how y'all would answer.
What do you think, Sean?
I mean, I would ask them, two questions. Do they know what a wholesale transaction is? And second, do they know what a subject to transaction is?
Andy, you want to go next?
Um, well, and again, so just to reiterate the question, we're asking what makes your title company investor friendly?
Or how do you know if your title company is investor friendly?
Hmm.
Let me tell you how I modify it.
I'd want to know what kind of dealings they've had in the past, I guess.
Oh, history. That's a good one.
History.
You know, because some title companies, I'm thinking some title companies, whether it's subto or anything else, it's like, oh, we're not, yeah, they're constantly having to go talk with a lawyer about whether that's even something they can do, and they're just because they're not willing to insure it. So history.
So you hit on one of the points. So the first thing I answer that with is you're not looking at a 20, 30, 40, 70, 100 office, corporate owned title office and asking, are they investor friendly? You got to look at the escrow team, because there's a office here in Texas. I think they have like 20 offices. They've got one escrow team for all their offices. We've got 3 or 4 escrow teams in our office. And so you have to ask if your escrow team is investor, and I don't say friendly, I say investor knowledgeable. So
Mm.
I convert the question into that. And then my smart aleck answer to that question is you ask the escrow team if they can do an ABBC sub2 acquisition, seller finance wrap, disposition with pass through funding and a pass through policy with a blind HUD. And that's how you know.
Man, well, if that's the case, then I don't know that I'm investor friendly because I was lost about A and B, and I was like, what?
But the key is the key is the escrow officer.
Yeah.
And there's what do we call there's escrow officers who walk by the assistant, grab the file, go in the close room, close, and then come back out, hand the file to an assistant, and that's all they do. Um, God dang, we have a designer escrow officer, and they're not actually knowledgeable. And you got to be careful of those. Now they can do that, and there's a couple of escrow officers I know that are, I mean, they're dang good, and that's what they do. But they also have the knowledge to back it up.
Yeah.
But if you have one that's a designer escrow officer without the knowledge, you don't want the team knowing. You want the escrow officer knowing.
Yeah, we have a title company here in town. We have multiple, but I've had 2 experiences with a title company here in town. The first one was I was consulted, assisted the client with putting the documents together. They chose the title company. I asked them, do you know their familiarity with the subject to transaction? And they said, well, I've called them. They said they can do subject to transactions. I said, okay, you're confident of that? Because I've never used them before. I'm not, I would recommend you go over here. But if you want to use them, that's your choice. I'm not going to push you, but just know that if you don't get the right title company, it's going to create major problems. And sure enough, that contract goes in and they're like, oh no, we can't do this. And they wanted to change all of the relevant substantive terms. Like, for example, I took out the due on sale clause for the deed of trust. And they said, nope, the seller has to have a due on sale clause. You can't just go and sell the property later on. I'm like, well, no, because what are you going to do with the property? Like, what if you want to do a subsequent wrap, You don't want the seller calling the loan due. And so it screwed it all up, and it was a major mess. Then that same title company was used again by one of my law partners who had a deal with them. And finally he got me on the phone and said, have you had experience? Go switch escrows, go to this company. They switched escrows and closed it in like a week. But they had been kind of dinking around with it for almost a month because the title company was just, messing them around on a subject to transaction. So yeah, having the right title company is huge, because if you don't, it's not going to end well. It probably will fall apart, frankly.
Yeah. Well, and I always say, I think I'm unbiased. Y'all can tell me if I am or am not. I think an attorney-owned title office is far superior than a corporate-owned title office, and I base that on neither Texas Department of Insurance or the State Bar of Texas preventing me from closing a file and representing one of the parties. I'm allowed to do that, and since I can do that, when there's an abstract of judgment or defective mechanics lien or this or the other, I get to actually come in and work on the file, while a corporate-owned title office cannot.
Yeah, so that works. So in states such as Texas, where you have law firms that also act as closing agents, that works well. In Arizona, we don't have that. We have title companies that are owned by attorneys, but they're not through law firms. They're just through title companies. So we only have title companies in Arizona. We don't have law firms that also act as closing agents that can underwrite title insurance like you guys do in Texas. So it's a little different here on that. And frankly, the title companies that are owned by attorneys, except if your name is Scott Horn, those attorneys don't really know the first thing about, subject to or even investor transactions. I mean, some of them may not even practice real estate law. They just own a title company. So
yeah.
Well, there is this podunk title office down in Austin who has some clue, I hear, about this business. I don't know who that is.
Podunk.
Podunk.
Hey, I'm from Pottsboro, Texas. I ain't podunk.
Are you really?
I lived up there. I lived up there before kindergarten and first grade.
I spent 50 years of my life going through Pottsboro.
Is that right?
All the way out to Preston Point.
Okay.
So, and grandparents from Denison, all that kind of stuff.
Yeah. Yeah. Grandparents were over in the Sherman Denison area. Exactly.
And you don't recognize it today to save your life going that way anymore.
Oh, no. I couldn't even find my old house. I'm pretty sure it was there, but I couldn't find it.
Yeah, I know.
All right. We've gotten off topic, I think.
Yeah. But anyway. We'll have to have that conversation another day.
There we go.
Fun stuff. But I'm just going to echo real fast what everybody just said, because I get so flippin' exasperated at people trying to close this business because all they care about is closing a deal. Cares about whether it was structured the right way, did proper disclosures get executed along the way, has anybody even thought about anything out there? They just want, I mean, I always say that this business is 90% disclosure and 10% paperwork. And trained monkeys can draft the paperwork, I guess, eventually. But your traditional title company, they have no idea how to do this, where to go, where to get it. They got to go find some lawyer who may or may not know how to properly execute the paperwork in these transactions. And then what are the odds of that attorney actually knowing the various requirements? I mean, if it's a wraparound mortgage, for instance, not just a subject to deal, what are the requirements that are out there for buyers and sellers today? Are they even thinking about this? Because we already know our buyers and sellers don't think about this. We hope they do, but they don't. And your traditional escrow officer, they're just lost puppies. They just want to go happy-go-lucky, close the deal. Let's just get going. We'll figure out somehow to do the deal, and they just close it, move on, and damn the torpedoes down the road. And there's probably 2 of us here in Texas who actually think through these deals, maybe 3 of us a little bit, about how you put these things together properly, how you protect sellers, protect buyers. So, we don't have to deal with more issues from a wonderful state government trying to shut us down.
Yeah. Well, and that's one of my fears with the real estate gurus out there teaching this investment methodology. And it's not necessarily the guru's fault or problem. It could be their students not going through the material and then going out, half-cocked or what have you. But you screw up enough files, legislature's going to come in, and they could wipe it out. They could have wiped it out back in before Senate Bill 43, but they chose not to. You screw it up enough, and they can get rid of it.
Yeah. Well, I got a question for you guys before you jump into the next 47 topics that Andy and Sean have for us, because this just keeps coming up left and right. If I say the word Morby method, have y'all heard of that before? Don't chuckle too loud. And I look at that and go, ain't no such thing as the Morby method. What do you do?
Well, Sean, hold on. Sean, aren't you the creator of it?
I know it, but I'm not the creator of it. It's a very complicated transaction that requires attorneys on both sides of the ledger, and it has to be with a fine-tooth comb to look over all loan documents and making sure that it actually can be accomplished and structured the way that that they're trying to do.
But Sean, I have a question for you.
Hold on. There's two Morby methods. There's the original structure that works. It's legitimate. It'll work. And then there's the morphed structure that has grown out of the original structure, and it does not work. So there's 2 different types, and it's very rarely the first type that we see here in Texas.
Define to me your second one, because that's probably what we're talking about right now.
So what happens is someone goes to a lawyer and said, hey, here's this Morby method using the entity structure that they have. And they say, well, no, you're not protected enough. You need to get yourself a note and deed of trust lien also. And that's what blows it up. Unless the lender is actually approving that second lien behind them, which 99 times out of 100, they're not going to approve. So what they're doing is, they're either doing it in the title office where they can get their hand spanked pretty darn good by not protecting the lender, or they're doing it in 2 closings and getting that second lien in place post-closing.
Yeah, but what I see these guys wanting to do is, so the first thing is you just said, out there, Alan, is that they don't want the lender to know that they're borrowing the money for their down payment from the seller. So if you don't disclose that, that's mortgage fraud. I go back to 08, 09, just going, yeah, no, guys. Then they say, well, hold the money in escrow for us. And after closing, we'll use those escrow funds to put a second lien on it. I'm going, yeah, same thing, only different. Don't like that. Now, if they actually close and fund the deal using their own money or wherever that money comes from, legitimately with full disclosure, cool. And what they do the heck after closing, so long as I don't know about it, I'm a happy camper. But
Yep.
they always want to involve us in this deal. And it's like, yeah, no.
Yeah,
We
no.
just had that call come in again, just literally before the podcast started. I'm just going, no.
So that's the key, right? And that is exactly it, is, making sure that all disclosures to the lender are accurate, that there's nothing in the loan documents that would prohibit a subsequent transaction between the buyer and the seller post-closing. And that you then fund the transaction, get it closed, and then you have your secondary transaction with the seller. I don't see a problem with that, as long as the loan documents don't preclude that.
No, but what they all want to do though, Sean, and this is going back to Alan's point earlier too, which is 99% of the time, because they ain't got the money.
Right.
And they want to use the seller's money to fund their down payment, almost always. And they think it's okay just to follow through that way, to escrow the money and use it after closing. And it's like, yeah, no, it's not. And you ask them, have you gotten permission from your lender in writing, this, that, those kind of items? And of course, they dance around the bush 14 ways because they don't really have it.
I have seen one team that has a lender that is disclosed that sellers bring in the down payment dollars and they're fine.
Really?
Yeah. One.
I kind of
Yeah.
I look at that and I kind of go, these DSCR loans for the most part are an asset-based loan, right? And I get that part, but what really, it's an asset-based loan subject to the buyer either having, and this is what I don't get about the DSCR world. I'm just going to table this for a minute and throw it out there a bit. If you own the house for 90 days, you can do a refi of the property at 70% of the appraised value. So if they're willing to do that, and someone wants to use a DSCR loan at 70%, but use the seller's money for the 30% down payment, in a sense, you can look at that and go, same thing, only different almost, right? And of course, the question becomes, does it really matter? Now, the whole thing there, we all know from lawyers, as being it's disclosure and those kind of items. But in a sense, it's the same daggum thing, just 90 days removed. Anyway.
Well, and when I have a seller come to me and say, hey, got some weird offer, ends up being the Mormon method, I tell them, you're taking a second lien position on 100% loan to value. And if there's a 5% drop in the market value of that property, it comes out of your 30% that you're putting down because you're in a second lien position. And usually they will bug out. And I had one guy, I literally told him that. He understood and went away and then came back and said, well, I want to close it. And now the thing's going upside down and he's all mad at me. And I said, hold on, I've got this in writing. I said, you're in second position. Any market downturn, you're first to lose. And so he's kind of skulked away a little bit.
I always wonder, these guys that do those kind of things, Alan, is what was the return they were offered? And all of a sudden, when you pull that back, it's not a standard interest rate return that we need here in Texas. All of a sudden, it's some percentage and this and that kicks up some astronomical interest rate. If you're living up in Andy's territory, you can do that. Sean, do they have usury in Minnesota?
Oh, in Wisconsin?
And Where up yonder, up north, Canada?
Yeah, I think it's like 18%.
Okay.
So,
So
but
they have something like that there. They just don't have that in Arizona.
yeah, so you're talking about like the earnest money lending and the transactional funding interest, which once again, that whole thing has been like revised and changed and is not being done the correct way. Um, so the so the original design of like the whole earnest money lending thing was to basically provide the earnest money deposit and basically be repaid the earnest money deposit as a loan with a very minimal interest, if any. But in exchange for providing the loan and procuring the loan, you actually take and you go on as an assignee of the contract and you take a 5% interest in the transaction itself and you get paid, you know, a 5%, 10% profit from the transaction as an assignee in the chain. I don't see a problem with that. I don't see usury in that. You are now part of the transaction and have a ownership interest, an equitable contractual interest in the chain that you get paid on as an assignment fee.
Which is that, I mean, that's common, you know, so someone has a deal, someone has money.
Right.
And you
Yeah,
join ventures at a 50-50.
Right. Yeah, I don't see a problem with that. I mean, if you know, and I won't use the term because, you know, I'm not, you know, but the whole idea was to take a chunk of things. That's the whole idea, right? Of like the earnest money lending.
Oh, go to your Alexa.
Is to take a chunk. And the way you take the chunk is you insert yourself as a principal in the transaction with a right to share in the profit. It may be a small percentage, and that share of the profit may be more than what would normally be allowed by usury laws, but you're not getting paid interest. You're just getting paid your loan back plus a percentage of profits.
Yeah, but the key
And
is
in that
you are
case,
a principal.
You are a principal, yes, but it's not being done that way,
No.
right?
It's
So
complicated
yeah.
for them to do it that way, Sean, is what I always hear, you know.
Well,
That's
Yeah,
why they
but-
like the one page whiz bang contracts. The Trek contract, you know, that's 9 pages. That's too long and it's too much to read. I like this simple contract, this simple one page contract, which provides no protection for either party whatsoever and is probably not enforceable.
You know, Alan, I'm just going to say this for everybody. I've said it before on here. You will hear these investors go, "Oh, it's just too complicated. The sellers don't understand it. It's too cumbersome to explain. It's too this. It's too that. You name it. It's you know, it's horrible." And I just go, "How in the world do you think these guys bought this property here in Texas? They used that exact same contract." So I guess they were dumber then, or more dumb now than they were then. I mean, what is it? But
I googled how many closings there were in the state of Texas for whatever year, 23 or 24, and it was something like, you know, 600 and something thousand. I said, so we've had 600,000 closings, so that's 1.2 million parties, buyer and seller. But for some reason, the 3 people that you're dealing with, they can't get through a Trek 1 to 4, and yet the 1.1999997 can.
I get it.
It's
I think
frustrating.
I think it begs the question, why if people can't bring themselves up to the level of understanding the deal that they're getting involved with, or you're at the point where you can't expect them to get to that point, why are you doing business with them? I mean, shouldn't there be kind of instead of assuming, you know, in government, we get mad at the government for always assuming that everybody's too dumb to handle a transaction. So we got to like do everything. But it's like when it comes to actually doing the paperwork right, it's like, oh no, nobody can handle that kind of complexity. It's like if they really can't handle that level of complexity, is this the kind of deal? Is this the kind of person you should be doing a deal with?
And someone, I think I was bitching and moaning about the difficulty of title office, running a title office, and someone said, "Hey, Alan, just choose your hard. They're all hard. Just choose which one you want." And so, if you want to be an investor, it's hard, and you got to go. You got to go put the time in, and you got to learn that Trek 1 to 4 contract. You got to learn how to do the Morby method correctly. You got to learn all that stuff.
Yeah, good take. All right, if you're just now joining us, this is the Creative Finance Collective. We are taking creative finance related types of questions. If you have them, make sure to post them in the chat and we will get to them. We do have some questions. I'll go ahead and pose those to you from YouTube. It says, I've heard the term subject to and wrap. Is there a difference between subject to and a wrap? As best I can tell, wrap and subject to are referring to the same thing. Well, we have Alan from the Wrap University, and Scott, I know you have plenty of things to say about this, as well as Sean. There is a difference between a subject to and a wrap. They are also terms that are oftentimes used interchangeably and just talking about a particular transaction. Why don't you guys break down the difference and what we on a technical level mean by subject to and wrap?
I think Scott and I differ on this, which is fine. My short answer is, from a legal perspective and from a documenting perspective, they're 100% the exact same. I've got a note in a subto transaction, or what I call non-qualified assumptions. I've got a note in deed of trust, and it's for the exact amount of what's the payoff of the note that's being wrapped. And then I have a mortgage wrap, which is usually a bigger note wrapping around the payoff of a smaller amount. So let's say payoff amount's $300,000 on a sub-2 wrap, we'll call it. It's a $300,000 note wrapping around a $300,000 note, and then on a mortgage wrap, a seller finance wrap, $500,000 note wrapping around $300,000 payoff amount due. So for me, they're exactly the same, and I like to call them all wraps. And then to distinguish what they actually are, I'll say non-qualified assumption or wrap, if we drill down to that. So that's my short answer.
I find it funny you use the word non-qualified assumption because, I was doing a seminar the other day and I was talking about the origin of the word subject to for the meaning of a subject to transaction, right? And, I'm going back to 2014, 2015, trying to figure out when it kind of came into being a little bit, because we used to call these just a silent assumption, right?
Yeah.
Because it was valid between seller and buyer, just not with the lender being silent in that regard. And somewhere along the way, the word subject to kind of got coined. It's kind of like hard money lending. I go back to the late 80s and early 90s, it was just private lending. And somewhere around 97, 98, it turned into hard money lending. Not really sure where that term came from. That'd be interesting to find out one day. But I look at the difference between a sub-2 and a wrap. And by the way, Alan, here in Texas, when you read our wonderful Senate Bill 43, the wrap lending bill, it actually classifies a subject to transaction as a wraparound transaction when you read the verbiage in that thing, which makes me think about other issues that could affect a subject to deal, not just a wraparound deal, because really they only intended it to be for a wraparound mortgage, not necessarily a subject to deal, but I think it kind of got rolled in. But I look at the flow of money more than I do, whether I don't use a new mortgage doc to do a subject to transaction like Alan does a new note in deed of trust maybe. We just call that a mirror wrap. Same thing, only different, got it. But to me, it's how the money flows, because in a subject to type transaction, however it's structured and documented, we buyers want to pay the mortgage company direct, because a seller can then easily go online, check their payment history, etc. And there's really no need for a third-party servicer to be incorporated in those scenarios. The only time you really incorporate a servicer in those deals is A, if the seller wants it, or B, if there's no escrow account on the underlying debt. Sometimes those sellers might want a servicer involved to handle the escrow account. Got it. But on a wraparound loan, the money flows from the buyer to the investor seller, who then pays the original seller. And so I usually look at that, defining a sub-2 deal versus a wrap, just on how the money flows. And that with a wrap, you add that one extra person in the middle, i.e. let's just call it the investor. So buyer pays investor, investor pays original seller. Now, of course, we don't let that happen. We incorporate the loan servicer in place of the investor in those instances. But to me, it's really how the money flows from deal to deal. Now, you can make a sub-2 a wrap and do it the same way as well if you want to. But I think I'm just going to back up and say the most traditional explanation of a wraparound mortgage is using Alan's example of a $500,000 loan that is the new loan to the buyer that wraps around the existing $300,000 loan, which then incorporates that payment flow along the way.
So I'll add a little bit of a twist onto that, just because transactions are done a little bit different in Arizona, or they can be, with agreements for sale. In Wisconsin, we have land contracts, which I know are more complicated to accomplish in Texas. But my understanding of subject to, or the way I look at it is there some lien, whether that's a judgment lien, a mortgage, a deed of trust, that is going to be listed as an exception on the title policy? Meaning, are you going to acquire the property subject to that debt or obligation? So to me, any time you acquire an interest in the property with some lien listed as an exception, a monetary lien listed as an exception to the policy, you're acquiring it subject to. So that could be, which I'm not a fan of, and I don't get involved in those transactions, whether you acquire it subject to with no wrap to the seller, and you just take a deed to the property and the liens remain, whether that's you provide a wrap financing or a mere wrap to the seller, or in Arizona, whether you acquire the interest via agreement for sale, subject to the existing loan. So my take is, anytime the liens are going to remain, monetary liens remain, there'll be exceptions on the policy, it's subject to. So not every subject to is a wrap, but every wrap is a subject to, if that makes sense.
Yeah.
Yeah.
All right, you just now verbally described a Venn diagram, correct?
Yeah, kind of.
Yeah, that's funny. All right. Good question. We have another question. Before we get to that, if you're just not joining us, this is the Creative Finance Collective. We're taking questions relating to creative finance. So post them in the chat on whatever platform you're on, and we will get to them as best we can. Another YouTube question: what common ways do you see investors plan for the possibility of triggering the due on sale clause? So I think this means a savvy investor knows that this is a possibility, knows that the transaction itself is going to trigger it. And what strategies, I guess, that do you guys think are effective in planning for the possibility of the loan getting called due?
I think that's possibly the best question that's ever been asked on this program. And the reason is, I want to get y'all's information as well as what I have. But step one, educate seller. You need to tell the seller this is a don't ask, don't tell transaction. I think Scott said silent wrap or silent assumption. You have to tell your seller in around 9 different ways three different modems: phone, text, email. That it's a don't ask, don't tell transaction, and we're not getting permission from the lender. We're not required to get permission. We're not required to disclose it to the lender. The legislature has stated I like silent assumption, non-qualified assumption, and step one is education and disclosures, and then step two is insurance getting put in place correctly, because that's usually what triggers a due on sale issue outside of inappropriate contact with the lender. So insurance, and then now step three is unfortunately utilization of the land trust vehicle. Home loan serve. We had another one just this week called due from home loan serve. No idea what's going on still. So we utilize the trust structure to, I don't like saying it this way, but it's what we do: conceal the transaction and keep it silent from the lender. So those are the three steps that we have.
Word?
What's that?
Can a lawyer use that word, conceal?
Rightfully and legitimately conceal.
How about disguise?
Those are my three.
What about and those are a good three. We'll let everybody else jump in also. But what about, have you seen, Alan, investors plan for what they're going to do on the front end, assuming it gets called? Like, okay, once it gets called, I mean, one way to plan for that is just be prepared to pay, I suppose, or get financing or whatever else. But have you seen creative ways on planning for that contingency to actually take place?
So there is a method. We don't know if our sellers are going to be available, and we may have to do a deed flip-flop to get this lender off of our back. And what I mean by that is deed it back over to the borrower, show the lender, and then deed it right back over to the buyer. Or you may do some type of lease purchase option for less than 180 days, plan on paying off the mortgage. In Texas, this is Texas law. But getting those documents signed in advance, a deed from seller back, from buyer back to seller, and from seller back to buyer, in case that seller is not available, is one of the preventative measures that's out there. I don't see very many people doing that. Other than that, I don't know of anything else that you can do to preemptively prepare.
You know, your first three things, Alan, dead on point, right? You know, it's just being smart, slowing down, doing things the right way, not letting somebody else do the work for you is one of my biggies. Because in today's world, you know, everybody tells the investor they're too busy, they're too important to do a deal. Let a TC do it all for you. And of course, they have no idea how to handle these transactions. When something pops up, they're kind of, you know, stuck in the muck and mire at that point in time. But, you know, with a land trust, you know, I'd have no objection to buyers utilizing a land trust if they're going to buy it as a fix and flip, a lease of some type for the property, or even live in the house. I'm good with that. But if you're going to do a wraparound mortgage on the back end, I'm not a fan of using a land trust up front, because as soon as you do a wrap from the trust to the back end buyer, you got a problem. And yeah, there are some ways that you can sell the land trust to the buyer, but it takes a whole lot more paperwork in between that nobody wants to pay for or go through and do you know, all that stuff with. And it's so if the back end side is going to be a wrap, I prefer just to close it into an LLC, because the percentages that I see of due on sale are pretty doggone small. But it can't happen, right? So disclose is the most important thing there. And then I'll use the land trust just in the various ways you described, which may entail having a deed back to the seller. Hopefully you've got good paperwork. So if you can't locate that seller, or you have an uncooperative seller, you've got a proper power of attorney to utilize things along the way so that you can satisfy the seller's issues. But one of my biggest things is if you're dealing with a law firm at that time and not with a mortgage company, deeding it back to the seller and then just immediately deeding it back to the buyer and recording that deed is probably going to be problematic. And so I'm going to want some kind of a written agreement between with the investor, seller, somebody, and based upon what's going on, to hold that deed in escrow for a prescribed time frame. But I want everybody's written approval on that before we just not record a deed somewhere. I think these law firms are smart enough to go online and see if there's been a conveyance within the last 30 days or so. Now, will they go out 45 days, 60 days, 90 days? I don't know. Doubt it. They move on down the line from there. But you just got to kind of be preemptive and think through a deal a little bit from a practical perspective.
Yep. Yeah, I agree 100%.
So we have a little bit more wiggle room in Arizona with our leases and options. I think preemptively, your relationship with the seller is huge. In making sure that everything was done properly, fairly, that the seller feels good about the transaction, that you're staying in communication with the seller, making sure that the seller knows, hey, if you move, if you relocate, change your phone number, blah, 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 let me know. If you have a servicing agent, let the servicing agent, and really try your best to stay on good terms with that seller. And then, if that letter comes out and you have a cooperative seller, then there are things you can do to meet lender requirements. So, in Arizona, we have potentially deeding it back to the seller and then doing an agreement for sale, for example, or deeding it back to the seller and doing a lease with option to purchase. Garden St. Germain, I think it's interesting now. I'm assuming that in Texas, if the lease isn't accompanied by an option, you can lease it for however long you want. But if it's accompanied by either an option or a purchase contract, you have to be within that 180-day window. So you couldn't have a purchase contract that went out like 2 years or something like that.
No.
Like with a close of escrow date out in 2 years. But in any event, in Arizona, we're not limited there. So we can have, a 3-year lease, up to a 3-year lease with an option or a purchase contract. I prefer a purchase contract. I've never seen a lender call a loan due simply because a memorandum of a purchase contract has been recorded. And do the lease with the identical terms. The purchase contract would have the identical terms. It would basically be business as usual, just a little paperwork reworking the transaction, if you will, if you have a cooperative seller. If you don't have a cooperative seller, like Scott said, you're kind of stuck relying upon POAs, refinancing, selling, those types of things. Land trusts don't work great here in Arizona unless the seller is the one to, like Scott said, the one to set up the trust, deed the property into the trust, and then convey the beneficial interest of the trust to the buyer. The problem with that is if the trust remains revocable, there are statutes that basically say that the trust remains liable for the grantor's debts and obligations for their lifetime. Not only that, but then the grantor still has the ability to, change or modify the trust, number 2. Number 3, what if you have an unscrupulous seller who takes the original trust to the title company and sells the property out from under the investor because they got cold feet and didn't like the transaction? How is the title company ever going to know about the assignment of the beneficial interest to that other party, right? Because the trust is going to look like that they can, in fact, perform. So there's a number of, issue. And then finally in Arizona, if the buyer is the trust, you have to disclose the beneficiary of the trust, which presumably would not be the seller at the time. So the beneficiary would be like a Wyoming LLC, which then would tip the lender off. So land trusts don't work so great in Arizona, but on the flip side, in Arizona, we have more workout opportunities than what you might have there in Texas.
I do have a quick question for you guys, for Andy and Sean. This is about Arizona. I was talking to one of my litigation guys today again about this wonderful solar panel issue we always run into. I get Texas stuff here. Are those handled any differently in Arizona than they are here in Texas?
So, okay, it depends on the circumstance that you're dealing with, but I do know from experience and even negotiating these things out on behalf of buyers who bought at foreclosure sales or otherwise, where here, the way it works in Arizona is and it may work this way in Texas, but basically you have a lien against the panels. You don't have a lien against the real estate. And so those panels, once they're installed on the roof, they're worth about $2,500. I mean, they're essentially scrap metal at that point. They're not worth the 40 grand that they were sold for. And so they're worth about $2,500. So if you are a buyer of the property and you didn't sign on the dotted line, and you choose not to pay the solar company, you could go to the solar company and say, hey, look, come remove the panels from my roof. That's your right, is to basically replevin, take those panels back. And oh, by the way, you have to put my roof back into the condition it was in before you installed it, in the watertight condition. But it costs them more to hire a roofer to fix your roof than those panels are worth. So they're never going to do that. And so then you say, okay, what about this? I'll buy them off of you for, $2,500 or $5 grand. Sounds much, much better. And then you could just buy them out. Now I'm not aware of these solar lenders pursuing the original borrower, the original homeowner on the debt, but in theory, they do have a right to file a lawsuit and pursue the borrower if the loan's not being paid. So it really depends on who acquires the property, how they acquire the property, all of that. But on a subject to transaction, you could build into the transaction from a seller's perspective that the buyer will pay that solar panel loan, and you could include that in your performance note so that you could then foreclose if payments aren't being made to the solar company. But they're a real hassle and headache, and frankly, they're ripping people off, these solar companies.
Well, I think it goes back to the old mobile home days. They know exactly how many people are going to pay, who's not going to pay, who's going to go through fruition, who's going to get foreclosed out, who's going to get this. They know what's going on, and they have enough built in to get the return that they're looking for. I mean, they ain't dumb, I don't think, to do that many deals along the way. But here in Texas, it's not too difficult to remove the liens through trespass-tried title action. These guys just won't ever let it go that far because they don't want to pay the attorney's fees. Mm-hmm. But trying to talk to a solar panel company is impossible. You got to find their number. You find someone to talk with. They won't let you talk to them. I went down to Houston, and while I was down there to go talk to one about removing it, and I wanted to speak to their dadgum general counsel, who I was debating back and forth with some emails with. I couldn't get past the front door to go to their offices or meet. They won't even announce me to anybody. So anyway, maybe it was just me. Who knows?
All right.
Well, and the rip-offs. They're rip-offs.
Yeah, that's a problem.
I agree.
All right, guys, we have a few more minutes. We have another question that we can probably get to in the amount of time. By the way, Ramon Preston from YouTube says, hey, guys, thanks always for sharing valuable information. So you got fans, guys. Keep providing the good information. Last question here. If from YouTube, if the buyer defaults in a wrapped subject to purchase, can the seller get get title back via a deed in lieu of foreclosure instead of doing the foreclosure process. No reason you can't do a deed in lieu of foreclosure on a wrap, right?
Just check title first.
Yeah,
Yep.
I mean, there are risks to doing that. There are consequences to not doing the foreclosure process. But there's nothing legally wrong with doing a deed in lieu of foreclosure. You just like everybody said, you got to do some title work to see what's popped up on the property since you did the deal, right?
Well, it's not so much that, but no, for me, I don't care what's out there behind me. You know, I want to make sure there's not a property tax lien, but if the first lien mortgage is being escrowed, that's not going to happen. And I don't care about any other liens that might be out there. All I care about is an IRS lien. No, an FTL that I'm looking for, so we give them proper notice.
That must be different in Texas, because if there's a lien that's attached to the property subsequent to the seller's deed of trust, such as a judgment lien, a junior mortgage or deed of trust, then when they do the deed in lieu and they give the property back to the seller who, was the lender, they give it back subject to those liens, and they don't go away. The only way to wipe them out in Arizona is to actually foreclose.
That's same here. That's same here.
Yeah, I agree.
Oh, okay.
Yeah.
Okay.
But I had this come up today again, guys. Talking about going back to Sean's point at the start of the program about, and yours too, Alan, about educating your seller. And sometimes the buyers. Deal down in Florida where a standard subto deal with a wholesaler, with a TC, deal closes. There's issues with recordation because Florida requires 2 witnesses on a deed, not 1. And, the seller is out there terminating or wanting to terminate the transaction, relist the property, claiming that the buyer hadn't made their payment. Well, it's like 6 days into the month. It's not even due until the 15th of the month. But these sellers are, it wasn't paid on the 1st, therefore you're in default. It's like, no, you're not. But then I come to find out somebody in this deal had drafted what's the word I'm looking for, y'all? The performance deed. Thank you, Sean. I'm going, well, who drafted that? And I have no idea. I'm guessing the TC drafted it. I don't know. And I'm just going, okay, did anybody inform the seller about that and what the rules and regulations are in Florida? Does anybody know what the rules and regulations are in Florida? Are you practicing law without a license now in Florida? Anyway, that deal blew up and went away, but it's like, goodness gracious. The seller didn't know what was going on. The buyer didn't really know what was going on. People are doing things in the middle of the deal, just to make a deal happen, per se. And all I'm going to say about deeds in lieu are, if you're going to use this or want to use this performance deed, you better daggum well make sure you talk to the right people in your state as to what the utilization of that really is. Can you use it? Should you use it? Those kind of items.
Yeah. Yep. Good information. All right, guys, that's all our questions, and we're just about at an hour anyway. So we'll go ahead and call it. Thanks for giving us your valuable time, Scott, Alan, Sean. We appreciate it, and look forward to doing it again next week.
See y'all next week. Appreciate it. Thank y'all.